Good afternoon. My name is Alena Shautsova. I am an immigration attorney from Brooklyn, New York. In today's live Facebook presentation, I would like to talk to you about what to do if I-130 was denied. I-130 is a petition by usually a U.S. citizen, a lawful permanent resident, to sponsor his or her relative into the United States for adjustment of status or for an immigrant visa. This is the petition that a spouse, for example, will file for a spouse. In this particular video, I will discuss about what to do if I-130 for a spouse. And there are two types of denials here. The first one is when your I-130 petition is simply not approved. The second one is a trickier one, is when the I-130 was initially approved, but after the interview, it got revoked. So what to do in the first case scenario? When you file I-130 for your spouse, let's say you are a U.S. citizen, you filed and your spouse is overseas, for example, and I-130 got denied because the immigration stated that, for example, you don't have sufficient evidence to prove that your marriage is real. This is a very common scenario right now. So, number one, you have two options when your I-130 is denied. You can either file a motion to reopen, and many do not know that it's possible to file it, because usually with the denial of I-130, in the denials there will be only one option offered to you, is to appeal. But you can actually file a motion to reopen as well. It's very important to know that. Or you can appeal. What is the difference between motion to reopen and appeal? In this particular situation, what's going to happen is that when you file a motion to reopen, basically the same, or that's how it should be, the same bodies that denied the petition is going to look at it again and see if the evidence that you presented now is sufficient to overcome the denial. Okay? And if everything goes well, basically the motion to reopen will be granted and the petition will be approved. If you may choose to appeal if you believe that the denial was based on application of wrong law, or the law was applied to you in the wrong way. Then it's better to appeal. And in the case of an appeal, it will be a different body that will be looking at your case. Not the same one, but a high one. Not the same people that denied. So there can be benefits in both situations, and it's a strategic decision what you would like to do, okay? To appeal or to file a motion to reopen. And by the way, just until recently, it was possible to file additional evidence when you are filing an appeal of a denied I-130. It's possible as well. So you will consider all your options and see what's better for you, for your case, what you would like. You also, of course, can always refile the case as well, by the way. That's a third option that you may have. So it will depend on the priority date, if it's important or not important, the filing fees, you're going to make those decisions as to what to do with a denied I-130 based on totality of the circumstances, so-called. Now, special note for those who believe that you can file I-130 just with forms. No longer so, okay? No longer so. If you file it for a person who is overseas, or you file for adjustment of status, even if you file for somebody who is here and is going to be adjusting their status, and you know the interview is going to take place, I would still advise you to file as much initial evidence together with the forms as possible. Why? Because nowadays, immigration does not have to ask you for more evidence anymore. They can simply deny your case. You won't even see the interview if they believe that the evidence that you presented with initial filing is very, very weak. So remember that. For all those who count on just filing the forms and then waiting for the interview to supplement their petition. There is risk involved. I would not recommend that. You need to really prepare your case well, even with initial filing. It's very, very important, because I know when some lawyers used to advise clients, oh, just file the forms. Another consideration, when you just file the forms and not much evidence, what if your relationship will break apart during the process? It happens more often than you think. You may not predict that, you may not count on it, and you may not want it, but it happens. And in this case, if one of the spouses, of course non-citizen, would like to later proceed by himself or herself, they still have to prove that their marriage was real. And guess what? If you just filed forms with initial filing, it will be very hard to do so. As you can imagine, if you would like to proceed by yourself, if the circumstances are such that the other spouse was abusive, that spouse is not going to cooperate with you to provide proof that the marriage was in fact a real good marriage and you had common funds together, joint accounts and things like that. So it's better to prepare well with initial filing. So that's in a nutshell what to do if I-130 was denied before it was approved. But recently we have more and more situations when I-130 gets revoked after it was approved, okay? So let's say everything was fine, you got your approval for I-130 and your spouse got the interview, you went through this NVC process, that's not an issue. But after the interview, the consulate now determined that the marriage is no good because your spouse, for example, was confused about certain answers, questions, and maybe they answered. Very often what I see is that the spouse answers questions, not that they're lying, but culturally there is a difference in understanding of the question. And guess what? The lawyer is not going to be there. The U.S. citizen or lawful permanent spouse is not going to be at the consulate interview. And that's how it happens. This bad situation that the consul decided that the petition was fake and the marriage is not real. All right. So if that happens, the petitioner will have 30 days to present additional evidence to USCIS. And at that time, USCIS will either reaffirm the petition, saying that it is in fact good petition and we did not make a mistake the first time when we approved it, or they will confirm the denial of the petition. And you know what? Very often the USCIS reaffirms the petition because remember, throughout all the process, not just for the initial filing, but until your spouse, non-citizen, will become a citizen, you need to be collecting evidence of the good real marriage. It's very, very important, okay? And if you do that, you will have no problems to withstand the challenges like request for more evidence or denial or revocation, okay? As long as you collect evidence, and what is the evidence we're talking about? Your communications. Prove that you're communicating with your spouse on a regular basis, right? Maybe you give them gifts if they're overseas. Maybe you travel there. Maybe you both go on vacations. Maybe you have other plans and proof of those plans, what you would like to do. Of course, it's easier to do that if your spouse is with you in the United States, like you have joint bank account, utility bills, affidavits from friends and family members that you guys do live together, lease, things like that. So it's very important to collect all that. But if you don't live together, communications, very important. Your text, Facebook messages, emails to each other, records of phone calls, that's going to be the core of your case. You say, you know what, we live apart, but we stay in touch all the time and look at our correspondence. And sometimes you have to disclose private correspondence as well. That's okay. All right, so that's what it is. But that's in a nutshell what needs to happen, how you handle the denial. So the denial is not the end of it, even if there is an accusation of marriage fraud. Remember that. And I have a couple of articles about the marriage fraud denial because it's the worst one on our website, how to approach it, what options are available, because there are different legal questions that come with a denial. And with a marriage fraud accusation, for example, one of them is that withdrawn petition cannot be denied. Sometimes a petitioner's spouse withdraws the petition and then the USCIS sends a notice saying, oh, we deny it based on marriage fraud filing. Guess what? They cannot do that. Withdrawn petition cannot be denied. There is a case law like that. So in each particular case, you will need to approach the situation depending on the facts and the law. So there is no universal advice as to how to deal with that. But that's something that you need to keep in mind, you need to be aware of. And remember that denial and whatever USCIS sends you is not the end of the story, not the end of your case. There are very often there are avenues available to you. And you can read more about immigration on our website, www.shautsova.com. Thank you.